All right, it looks like we already have a lot of people in the webinar. So yes, again, so I'm Ben Warner. I lead marketing here at Privado AI, and yeah, we're excited to have you today for this session on the latest with what's going on with the CPPA and all the latest enforcements, regulatory updates. So before we get started, I just wanted to highlight that this session does count for IPP CPE credit. So you can go log into your account and there's a form you can submit. If you go to the webinar uh, registration page, the instructions are at the bottom. And also throughout the session, please do ask any questions you have on the presentation or anything on these topics. We'll try to answer them during the presentation, if not afterwards. Also, the session will be recorded. We will send out the recording to everyone and we'll send out the slides to everyone once we complete. So, with that being said, I'd love to hand over to Josh Hansen. So he's our legal expert today from Shook, Hardy and Bacon law firm. He knows the ins and outs of the CCPA and all these new updates. So we're very happy to have him. I'll pass over to you, Josh.
Thanks, Ben. Yeah, today we're going to cover just the last couple months of what's happened in the world of the CCPA. And while it's just the last couple of months, we only have an hour, and there's been a lot. We have new regulations, we have new enforcement activity, we have some name changes. We're going to cover the gauntlet here. So, as Ben said, my name's Josh Hansen. I'm an attorney out in Denver's Shook, Hardy and Bacon office. My focus is on privacy and cybersecurity, with a particular emphasis on state privacy laws, state consumer privacy laws. If you have questions during the presentation, please just put them in the Q&A. Happy to kind of make this more of a dialogue. It can be a lot if it's just me talking at people. And if after the presentation something struck your fancy or you have some questions, feel free to shoot me an email. Emails here on the screen will be sent out in the presentation as well. So we're going to cover 4 topics today. One is the new and updated regulations. So this year-long process that the California Privacy Protection Agency undertook finally wrapped up in September with approval of these revised regulations. And there's a lot to digest. We're nearly, I think, 100 pages of regulations. So there's a lot to actually dig into. We're also going to cover the Opt Me Out Act, which is new legislation that passed through the California legislature this year. It's going to talk about what the impact is for businesses, what are the unknowns, and what you might want to do to think about operationalizing it. Third, got a big catch-all category, enforcement trends and activity. There's a lot there because both California has 2 privacy regulators, the California Attorney General and the California Privacy Protection Agency. Both have been active, both in slightly different ways. And so we're going to dig into what they've been doing and what your business should do to prepare. And wrapping up with some practical tips. Now you have these new regulations, you have new laws, and you have some background enforcement activity. What are the things you can do to minimize those risks to your businesses? So, starting off with the new and updated regulations, AI, audits, assessments, and more. It's not technically AI. The California used the word automated decision-making technology. It's a subset of AI. Basically, we'll dig into more what specifically that is, but for our purposes, think about it as AI that's going to give you at least put you in the right direction. Now, I think when every business starts off with these new obligations, they're thinking, okay, what's my timeline? So California was a bit nice here. They've delayed some of it. Some of it is not taking effect right away. Some is. So first off, we have the updated regulation. So a couple of years ago, California put out initial regulations, privacy policies, opt-out rights, consumer rights, access, notice of collection, all of these. They've updated those with some new obligations and a lot more details. Those take effect first of the year. So you don't have much time to start bringing measures up into compliance. So that's something you probably want to start prioritizing. We also have risk assessments. There's the effective date here varies based upon the activity. If this is something that you are just starting in the new year, you need to complete the risk assessment before you do it, starting January 1st. But if it's an activity that falls within the scope of risk assessments, and you've been doing it already, so before 2026, and you don't make material change to it, you don't have to complete that assessment until December 31st, 2027. So that gives you a 2-year runway to kind of get your ducks in a row and align with the new regulations. Third big one, cybersecurity audits. This has, again, a staggered effective date. If you fall within scope for the requirements for a cybersecurity audit, your effective date depends on your revenue. So your audit will need to cover the 2027 calendar year, and you need to submit a report by April 1st, 2028. If you have greater than $100 million in revenue in 2026, your audit would cover 2028, and you report it in 2029 if you have greater than $50 million in revenue in 2027. And then April 1st, 2030 is a reporting deadline for everyone else who's within scope. So it's kind of nice that you get a couple of years to ramp up, especially for some of these small businesses, because that cybersecurity audit, as we're going to dig into, there's a lot to do. Finally, the automated decision-making technology. This is the consumer notice, this is the opt-out rights, this is the operationalizing those disclosures and more. It takes effect January 1st, 2027. But because there's so much there, you don't want to wait until mid-2026, late 2026 to say, oh, yeah, we got to get these operationalize these things. How are we going to do these opt-outs? How are we giving people access to the information? Start planning now. Start talking with your business teams. Start talking with your technical teams, and you'll be prepared. So first, we're going to start off with talking about the updated regulations. One of the major changes here was they shifted a lot of things from permissive to mandatory. If you look through the original regulations, a lot of it was, you may do this, you should do that, you can do this. Well, California said, nah, we really say you have to do this. So for example, previously the regulation said you should not use double negatives. Well, now you must not use double negatives when you're talking with consumers, informing consent. It said you can test for dark patterns. Now you must test for dark patterns. You could display a verification that you honored an opt-out signal. Now, as we're going to talk about in a minute, you have to display that validation. Also, there's new requirements around your privacy policies. Some of the changes are tied to other regulations, such as disclosing information about automated decision-making technology, ADMT, as I'm going to use it kind of throughout this presentation. The biggest one, though, for a lot of companies that's going to be impactful on January 1st, 2026, you need to disclose the categories of data you share with your service providers. So no longer are you just talking about disclosures of third parties. Now it's your processors, or in California terms, contractors and service providers. I do hate to break it to you, California has not actually clarified the distinction between a service provider and a contractor, so I think everybody's just going to continue to treat them as one and the same. The third big change to the regulations is consumer rights. So consumers have the right to access data that you have about them that's more than 12 months old. But now, in that process, when you're presenting them that form, you need to make it clear they have the right to request information beyond 12 months. So maybe that's a calendar dropdown saying, hey, I would like information from the last 3 years. But don't worry, it doesn't go back before 2022. So records you had before then, not in scope. The other big change, which might be a little bit harder to operationalize, is the right to correction. So not only do you have to correct the data, but you have to make sure that it actually remains correct. So think about a company who has a database, and on weekly basis, they get it refreshed by a data broker stream. Well, the data broker stream might continue rewriting old, incorrect data to the database. You need to make sure that after you've honored a right to correction, you flag that information to make sure it doesn't get overwritten with the same incorrect information. Going to require some technical thinking and operational difficulties. The fourth major change, I would say, is around the opt-out right and the right to limit. So I kind of hinted at this before, but now you need to display the election of somebody who's, once they go to your website with a global privacy control or universal opt-out preference signal, you need to display whether you're honoring that right or not. So maybe it's a green light that says opt-out signal honored, or some other toggle that lets the consumer see, oh yeah, my preference is being honored. Beyond having that, you also need to have a method for a consumer to check in with you and say, hey, are you honoring my request to opt out of sales and sharing, targeted advertising in California terms? Or are you honoring my request to limit the use of my sensitive data? This is different than what I talked about with the opt out of the global privacy control, where you have to have actually display something. Here, you just have to have a way for a consumer to ask you and you to confirm, yeah, we did honor your opt out preference. And finally, the fifth biggest change is service provider contracts. And this is only here because this is actually a tangible action item that I think regulators have paid some attention to. Gonna have to update them. There's new requirements. Big one is you need to require your vendors to assist you with audits, risk assessments, and any obligations you have with respect to automated decision-making technology. There's going to be some new standard language that goes in each contract, but you're going to have to amend existing contracts. And again, this takes effect January 1st, 2026. So there's a short time frame to actually make those changes. That being said, I can't expect that regulators would be too closely focused on this if you're not done by the first of the year. They realize, as a practical matter, amendments take some time. But I also suspect that these will not be difficult amendments because you're just basically parroting language from the regulation. So let's get into the new fun stuff. The first major new category here in the regulations is risk assessments. Now, they didn't completely recreate the wheel here. This term risk assessments is what everybody else is calling a data protection impact assessment. You have a lot of these in different states if you're subject to other states' privacy laws already. But there are a few differences here that it's worth flagging. Before we get into it, just want to back up and take a big picture view of what these risk assessments are. You're assessing the risks of the processing, assessing if the risks to the consumer outweigh the benefits to the public, the business, the consumer, or others. So you're not just asking, hey, is this better for the consumer than it is, or there are greater benefits to the consumer than there's harm to the consumer? You can consider the benefits to other parties as well. So I think it's a notable and important consideration considering the impact that some of these activities may have. Now, these triggers, for those of you who have operations in other states, aren't going to seem that surprising. They mirror a lot of what we have seen elsewhere. You've got your selling of personal information, targeted advertising, processing sensitive personal information. But we also get into some of this automated decision-making technology. So beyond just profiling, it's significant decisions. It's training these systems. Those are new triggers that you're going to have to make sure that you're spotting and assessing, hey, we need a risk assessment for that. And how are we going to do that? So, okay, you figure, oh, I've done risk assessments before. They're fine. They're simple. Well, California's going to add some wrinkles. These are more along the lines of the Colorado approach, where you had regulations getting into a lot of details about what they expect and what they want. Contrast that with other states where we don't have regulations, and it's more of a high level, hey, conduct this assessment, review the risks and harms. Maybe there's a couple of considerations. California goes into a laundry list of details that you need. So some of the major ones, you need to document in the assessment who provided the information for your assessment, who reviewed those details, who has the authority to decide whether to move forward with the project. And one of those people who has that authority has to be involved in the assessment. So it can't just be shepherded off to the legal team. is going to have to involve some of your business people as well. And in that risk assessment, you need to document, are we actually going to move forward with this project? So it's not just a check the box exercise of, oh yeah, we did this assessment, we're done. You're actually going to have to weigh these benefits, the harms, the safeguards, all these things to say, hey, can we actually move forward with this? And sometimes maybe not. Or you need to go back to the drawing board and think, how can we do more to minimize those risks? What safeguards can we put in place? Do we need all of that data? Can we use less data? Can we get more? Can we get consent for these activities? Think more along the lines of a rigorous review rather than check the box. Now, the other big thing here is you have to do, it's not a set it and forget it. You need to review these assessments at least once every 3 years. But if you do a material change to the activity, you need to review it within 45 days, if not sooner. Now, what's a material change in this context? The agency gave us some examples. Is there a new negative impact? Is the risk or likelihood of a material impact or the magnitude of that impact greater because of how you've changed the processing? Or have you made a change that's diminishing the effectiveness of those safeguards? So there's a lot to think about when you're updating and undertaking new activities or revising activities. You're going to have to continually be thinking about, oh yeah, there's those audit or those assessment requirements. We need to make sure we're updating that before we actually start this new activity. And in terms of the timing, you have until you have to start it, the assessment, and complete the assessment before you start this processing. The one exception here is that any processing that falls in scope that you started prior to 2026. As I talked about earlier, that risk assessment just has to be completed by December 31st, 2027. But the caveat there, if you make a material change to an activity you started, say this year, you're gonna have to complete a assessment before you implement that material change. Another interesting twist here that California added is these assessments don't just sit in a file somewhere. You need to actually go to Cal Privacy, which is their new term for this California Privacy Protection Agency, CPPA, and attest, hey, we've completed this number of risk assessments. Here's the type of data that was involved in those risk assessments and how frequently we've done them, when we did them. You're not submitting the actual risk assessment though. So don't be worried about waiving privilege or other considerations like that. It's just more of a high level review of your risk assessment you provide to the agency. But the person who's submitting this attestation to Cal Privacy is going to be, has to be an executive member. So there's going to be some increased liability risks for executives, and they're probably going to want more assurances from more line level people about, hey, did we actually do this? What does this look like? Because they're signing their name on the document attesting to something, and they're going to want to not take on increased liability without additional safeguards. And I think in terms of a practice, when you're thinking about these risk assessments, don't think about rebuilding the wheel. You can leverage what you've done for other states and just build upon that. I think the easiest one to build upon will be Colorado, just because there are going to be a lot of similarities. But if you're establishing a baseline, California is going to cover most, if not all, of the other states as well. So you're going to be in good shape.
All right, we had a couple questions come in before we move on to cybersecurity audits. The first one is going back to the piece about service provider contracts from Heidi. I included the certification under the CCPA in an agreement, and the service provider argued that they are a contractor. I countered that their activities were those of a service provider. Are there any arguments to overcome this challenge from a service provider?
Yeah, I mean, I think those are really tough to me, or tough to win one way or the other, because the definition is just so unclear. I've yet to hear either a regulator or practitioners or business people make a good case about why one or the other. One way I've seen this be approached is rather than saying, hey, we certify, you could say, to the extent we are a contractor, we certify X. And so you're caveating it saying, if we are, we're certifying. But at the end of the day, it's not exactly clear what that certification provision gets someone anyways. If you are certifying but you're non-compliant, you're going to have a separate breach claim anyways. So that would be my argument. Talk to the other party and say, what is your real concern here? Because if you violated the certification provision, you're violating some other provision already. So that would be my retort.
Thanks, Josh. We have one more from Amy. Can you comment on how these updated regulations apply to business companies, meaning that companies that don't sell to consumers, only to businesses?
Yeah. So again, it doesn't change the scope at all. It just changes the requirement. So to the extent you've viewed yourself as outside of the CCPA already, it's not going to have an impact. But remember that the CCPA does cover employee and applicant data. So you might still be within scope for the CCPA, even when you are doing business to business transactions.
Okay, great. We have another one along the same lines, actually, on the applicability to nationwide staffing agencies dealing mainly with temporary workers. If the agency does not staff in California but does temporarily hire staff who reside in California, would CCPA apply? It'd be helpful to know whether and to what extent we need to be concerned about these changes.
So there, I really want to focus on if these people are California residents. The CCPA does apply to California residents. They do have those rights obligations. And California, again, has a trigger based upon revenue, so not necessarily volume of data that you're processing. So you could possibly fall within scope. At some point, it becomes a risk decision. Like, okay, how much context do we have there? What's the likelihood of enforcement? And what's the compliance uplift? You have to consider those things. But in terms of application, it just comes down to, hey, are we meeting the revenue threshold? If yes, are we processing data on California residents? It's going to be, you're going to have technical compliance obligations.
Awesome. One more question just came in from Athena with regard to risk assessments and new process activities started after January 1st, 2026. Are you seeing that a risk assessment is required prior to starting the activity, or do we have until December 2027 like we do for existing processing activities?
So if it's a new activity or a materially changed activity, you have to do the assessment before you undertake it, starting January 1st, 2026.
Great. I think that's it for now.
Okay, let's move into cybersecurity audits. Here we're getting into the security components of CCPA, and really the focus here is on your information systems and your processes and procedures to protect against the unauthorized processing of personal information. Now, these audit requirements don't apply to every business. There's a couple of different thresholds. One, you can be in scope if 50% of your revenue comes from sales, or two, you meet the CCPA's revenue threshold, which is a hair above 25 million now, and you either process personal information on 250,000 people in a year, or you process sensitive personal information on more than 50,000 people in a year. So these numbers are relatively low, especially if you're doing business in California. So a lot of companies are going to fall within the scope of these cybersecurity audits, and there's a lot here. So when you look at what this review entails, the auditor needs to be looking at how are you implementing and enforcing these obligations? What kind of documentation? Are you have policies, procedures? How are those shared? They also list 18 detailed controls. So think about multi-factor authentication, encryption, things along those lines. And the auditor has to address those if they determine they're in scope. Most of these are going to be in scope. And so they take up quite a few pages in cybersecurity audits to dive into the level of detail they want on each of these controls. The auditor also has to examine, hey, are there gaps in the program? And what is their kind of plan for addressing those moving forward? What's interesting is that as part of the audit, the agency said the business has to make a good faith effort to proactively disclose relevant information. So the auditor doesn't have to just be hunting and asking the right questions. The business has to share this information. At least that's how I read the regulation. Again, they're so new, we don't really have regulatory guidance here. It's going to be interesting to see how the agency explains and what they kind of talk about on the conference circuit about what their expectations are. Because, like, I'll be honest, there is some ambiguity. I think there's some alternative readings people could have. But if you want to take a conservative approach, as a business, you should be trying to give the information to your auditor proactively. And not surprisingly, the requirements also say you have an obligation to make available information the auditor does request. You can't just withhold it as long as it's relevant. So we talked a bit at the beginning here about when these audits have to start. It depends upon your revenue. So if you had greater than $100 million in revenue in 2026, your audit needs to cover the 2027 year. And then it goes on from there. If you have $50 million in revenue in 2027, your audit has to cover 2028 year, and onwards we go. But we get into what the auditor has to be. Interestingly here, they have a relatively benign standard, qualified, objective, and independent. But they do make it clear you can have an independent, or you can have an employee auditor. But there's a lot of different restrictions on what happens if you do use somebody who's within the company. That auditor has to report to the executive committee member who does not have responsibility for the cybersecurity program. And there's also conditions about how you can pay that auditor, who sets that auditor's pay. It might be more hassle than it's worth to have an independent or to have an employee auditor. It might be worth the extra cost to go out and bring in a third-party auditor. Another restriction on the employee auditor is that they can't participate in any of the activities that they might assess. So they can't be helping build or find the cybersecurity program and then turn around and put on their auditor hat. The agency also specified what kind of evidence you kind of have to be looking at. You can't just, the auditor can't just say, hey, management told me they have X, Y, and Z. You got to look beyond just management's assertions. You got to look to talking with aligned people, looking at documentation, doing your own review. And that auditor has to report up to the executive management team, regardless of whether they're an employee or not. Like the risk assessments, we have a certification requirement from an executive. Again, the California Privacy Protection Agency is asking executives to put skin in the game. They're signing their name saying, yeah, we completed this audit. We did not unduly influence the audit. And I think any executives who's signing their name on this is going to say, hey, how do I know this? How do I know what Joe down in IT did, or Jane over on our cybersecurity team? They're going to want to get verifications. They're going to want to have discussions before that executive is willing to sign their name and certify under perjury. So think about how you're going to operationalize that and who's going to be that member signing that certification. Importantly, you're not submitting to the agency your cybersecurity audit. You're not saying, hey, we had these gaps, we had these weaknesses. No, you're basically saying we did this audit and a few more details. But that audit, the actual audit itself, remains with the company. Here, I think what companies should be thinking about is, what do we already do that matches this? And how can we build on that? So for a lot of companies who are using a NIST framework or maybe subject to NYDFS, the New York Department of Financial Services regulations, they probably already have audits that they undertake. And you want to say, hey, let's map those requirements against California's requirements and identify what gaps are there and what do we need to fill in. Because California says, you can go ahead and use existing audits. You just have to build on them to make sure they cover everything we require in ours.
That's great. That actually answers one of the questions we got about reusing ISO and NIST audits. So I think that covers that one. Um, there's another question about the reporting to executive management team. Does that mean from an org reporting perspective, or that the audit report must be delivered to the executive management team?
Both. So ultimately, the senior auditor, the top auditor, has to report to the executive management team, and the audit report does go up to the executive management team as well.
Okay. One more question we got about service providers. If you're a service provider acting on behalf of a business storing slash processing PI, do the cybersecurity requirements apply to this service provider?
The cybersecurity audit requirements, I do not believe so. I believe this is just for the controller, so the business in California parlance.
Got it. Thank you.
But that being said, I would not be surprised to see the businesses pass down obligations onto their service provider, saying, "Hey, we need these standards, or we need this information," because that's going to be part of the business's audit, saying, "Hey, it's not just our systems, but it's our expanded. Where do we process data? How do people use it?" So that's probably going to come in. You're going to get more questions, which tracks with the updated regulations that talk about revising your contracts to include compliance and helping with cybersecurity audits.
Thank you.
So here we have the automated decision-making technology, the third major change here. So the obligations here are about giving notice and new rights if there's automated processing of personal information to make significant decisions with limited human review. Well, what does that really mean? So they define automated decision-making technology as any technology that processes personal information and uses computation to replace human decision-making, or basically the business uses the output to make a decision without human involvement. So if this technology is using PI and making decisions, and making one of the covered decisions, which we'll talk about in just a minute, okay, that's automated decision-making technology. But maybe you say, hey, we do have a human in the loop. But that human actually, they specify what that review they have to have, what authority they need to have. So one, to avoid being in scope of automated decision-making technology, the human has to know how to use the output. They have to actually review and analyze the output and have the ability to change the decision made by the automated processing. So it's not just enough to say, hey, we have the human rubber stamping it. They actually be knowledgeable and involved. Otherwise, the California says, basically, this is technology making a decision. So it doesn't apply to all decisions. It's kind of like we've seen in other states, like when you look at Colorado's law on AI, targeting high-risk decisions. So it's about providing or denying things such as credit, hiring, medical care, a pretty touchy fields, I think. It wouldn't be surprising to say, oh yeah, these are pretty significant decisions. In terms of what this imposes on companies, if you're using automated decision-making technology to make these significant decisions, you need to give consumers the right to access some of the information, like what's being used, how it's being used. You also need to give them notice. So why do you use the ADMT? How it works? What rights are available? And this notice has to come to the consumer before you use the automated decision-making technology. So figuring out how you're going to actually share that information is going to be difficult. And then finally, there's the right to opt out of having this automated processing. So there's a couple exceptions to the opt-out right. I mean, one of them is if you offer individuals the right to a human appeal. So you can say, hey, if you don't like the decision, you can have a human reviewer take a look at it. Okay, you don't have an opt-out right. But that seems pretty functionally the same. Then there's also no opt-out right for certain employment or hiring decisions. They specify those are regulations, but I think for the purposes of today, it's just enough to flag there are some carve-outs to this opt-out right. And these obligations start January 1st, 2027. So you're going to want to look through system and figure out where are we making significant decisions and how are we making those? Is there a human in the loop? So that covers all of the regulatory changes that we've seen so far in terms of new and updated regulations. So let's move on to legislative developments. This year, the California legislature passed the Opt Me Out Act, which a similar bill passed last year, but was a bit broader. So let's kind of talk about first what this new bill does. This requires companies who share a browser to include an opt-out preference signal. So similar to the goal privacy control, it might be that, it might be another form of the universal opt-out signal. And this is going to make it a lot more accessible for users because, hey, I'm talking to my parents, they can use computers, but they're not going to go download a global privacy control extension. But if they start their browser and it says, hey, do you want to see targeted advertising? Do you want your information shared with all these people? My parents will say, oh, no, I don't, probably. They click the button and say no. That's going to increase the number of opt-outs. And it's interesting, California specifically said you have to make these options easy to locate and configure, and you basically explain how it works. So I think what you're going to see is opt-out signals are going to go mainstream. That's going to be a lot more opt-outs, and that's going to require a lot more of a compliance lift on the back end to make sure you're honoring those. It might encourage companies to look for alternatives to targeted advertising or similar metrics to get the information they need to power their business. It takes effect a year, or in 2027, just about a year from now. But there are some really open questions that I think are worth flagging. The bill said, or the law now says, the California Privacy Protection Agency can issue regulations. What are those going to look like? Where are those on Cal Privacy's radar? Right now, the agency said we're looking at like employment regulations and some other things. How quickly can they move on this as well? Do they have enough on their plate that we're looking at expanded obligations soon from the agency? Does it apply to mobile browsers? Well, it's not really clear. How are companies going to do this outside of California? So while it says if you're in California, you need to provide this signal and make it accessible, are companies going to have two different installs? A California browser and a non-California browser? Maybe. But if they don't, you could start seeing a lot more opt-out preference signals from other states as well. And want to figure out how you're going to honor those and where you have to honor those. Now, I start from the beginning and say, this is basically a copycat of last year's bill. There are some changes. Last year's bill, which the governor vetoed, required that there be a opt-out for mobile operating systems. Companies were like, I don't really know how we're going to operationalize that, what that even looks like. This year, they took that out, and it passed again, and the governor signed it. So we have another new way of opting out. So now to the meat, I guess, if we will. Regulations are fun. What is it that regulators are actually doing here? So let's talk about these enforcement trends and activity. I think if you've seen the recent trends, it's settlements, it's enforcement activity. It's people are no longer just sending out cure letters or working behind the scenes. I think California agencies moved from an educational aspect to saying we're actually interested in making sure people are following the law, not just educating about it. So a few notable developments here. I've kind of been talking about this throughout. The California Privacy Protection Agency kind of announced a nickname, Cal Privacy, which I got to admit, I'm a fan of because it was getting really confusing talking about the CCPA, CPRA, and the CPPA. Just too many acronyms, too close together. So Cal Privacy, fully on board with that idea. Love the name. It tells me, oh yeah, that's something different. We also, the other big things are regulators are working together. And that's increasingly true. I mean, I think it makes sense from when you see these are really large companies you go up against, and these forces or the regulators don't have a large number of attorneys. They have a few people, they have some technologists on board, but it's really about how can we work together on issues that are nationwide issues. So we've seen regulators join forces. California and Colorado and Connecticut, they said, hey, we're going to do a joint sweep of opt-out preference signals. Our company is honoring these. We've also seen a privacy consortium form up. We have 9 states, which includes 10 regulators, because California, again, has 2 regulators for privacy, Cal Privacy and the Attorney General, working together on these issues. And in fact, at IAPP, a recent conference, regulators said, hey, we're kind of delegating some of these tasks to states where they're getting experts. So Indiana might be focusing on medical privacy. Delaware might focus on connected devices. And they're leveraging that expertise and talking across states. Regulators are in constant collaboration. So when you're thinking about, well, what does that mean? Make sure if you do talk to a regulator, you're saying the same thing you're talking to saying someone else, because they will talk and they will work together. And if you're saying one thing to one and something else to another, that's going to come back. And in terms of enforcement, we have seen recent settlements. And so let's dig into those. So Tractor Supply is interesting because it's the first time where the agency actually went to court to enforce a subpoena about a privacy issue. Tractor Supply allegedly was not providing all the information that the agency had requested. Shortly after that lawsuit was filed, the settlement came out. Now, the agency said focus on 3 main issues for Tractor Supply, which are not going to be surprising because we've seen them in other settlements. First, the privacy policy. They said, you're not giving information that consumers and job applicants actually need and are actually required by law. What's interesting here is this is one of the first settlements, if not the first settlement, where we see them going after employee applicant data as well. So remember, California is the only one that treats employee data and applicant data as in scope of their privacy laws. So when you're thinking about your privacy policies and disclosures, if you're operating in California, you're subject to the law, make sure you have that employee and applicant policies as well. The second one was the opt-out. They said, your mechanism just didn't work. So you had a web form, but it didn't actually turn off the tracking tools when you used it. And you had said you honored, or you're supposed to honor the opt-out preference signals like the global privacy control, but you didn't. These, again, are low-hanging, easily accessible, and visible issues. So the agency didn't even need a subpoena to see this wasn't working. They could test it themselves. And this is not only what regulators are doing, but plaintiffs' attorneys are also doing. They're saying, hey, your website said I can opt out of cookies. I did that. But you still were sending my data to the advertisers. You weren't honoring my request. That's going to be that has been and is increasingly becoming a bigger risk both for regulators and private plaintiffs. So if you're looking at one of the low-hanging fruits, check and test your cookies and your cookie management system. The other one thing they flagged them for was, hey, your contracts, you didn't have all the necessary terms in there. This is one where I think that was, if I had to guess, my expectation is the agency saw these privacy policy and the opt-out issues, started investigating, and then found these non-compliant contracts. These contracts, you had to request them. It's not something the agency could just go and see publicly. So what was the result? Well, we had the largest privacy settlement from the state, 1.35 million. The company has to undergo a cookie scan and they update their inventory at least quarterly, which makes sense because, again, part of this issue was their opt-outs weren't working. They need to check with their opt-out systems to make them working, and of course, update the privacy policy to actually make them compliant. Not a huge surprise. But I mean, I think the three big takeaways here are, yeah, besides the fact that we were dealing with similar issues that we've seen in other settlements, privacy policies, opt-outs, three things to take away here is applicant data. That's a first. There was court action. They were willing to go to court to fight these for the subpoena. And three, we have the largest fine that's been issued yet. That shows they're taking this increasingly more seriously and the risks are real. So as compliance costs, it's no longer a ticky-tack fine or, hey, maybe a letter. The costs here are real, and so maybe that changes the calculus on how you operationalize compliance. What's notable here is the agency did also say, and it's probably worked in their favor, they made changes during the investigation and have dedicated a lot of resources. That was while the investigation was ongoing to fixing these issues. So if you are caught, it's good to show good faith effort in working to resolve these issues. Sling TV is a settlement that came out just October 30th. It was announced actually during the IP's recent conference. And this was notable for quite a few reasons. They had a variety of issues targeted around issues we've kind of seen before, both a new twist. So Sling TV had a cookie banner, an opt-out signal or opt-out page, but it directed to the cookie preferences, which made people think, oh, yeah, if I opt out of the cookies, then I've opted out of the sales. That's what they're telling me, right? Not what happened. In fact, if you opt out of the cookies, it didn't opt you out of all the sales and sharing of data that the company actually did. You had to go find another form, which was buried deep within hidden menus and small font to go find out, hey, I actually need to do something else to opt out. Agency was not a fan of that mislead. I mean, similarly, they said, basically, you had dark patterns here. To get the full opt-out, you had to go through this whole rigmarole, and it was a lot. It wasn't an easy, understandable process for consumers, and it was deliberately intended to keep people kind of opted into these sales. They also dinged them for data requests. If you were logged into the Sling app, so Sling knows who you are, they still require those users to give more information. Some of it that Sling would have already had because you were logged in. And the agency has said this before, request only the data you need to honor the request. So the fact that Sling was asking for more wasn't okay, didn't fly. They also targeted the company for how people opted out when they were in the app. They had to go online and enter in a 55-character URL. You couldn't just click a button in the app, which is notable because most people interact with Sling. It's a TV platform through an application. And agency's regulations say if you are offering opt-outs, you have to provide them. You can use telephones, you can use all these other methods, but at least one of them has to be how you interact with consumers on a regular basis. And the fact that you couldn't do it through the app, that was a big problem. Compounded by the fact that it wasn't an easy URL. It wasn't like, hey, sling.tv/opt-out. It was a long number of characters that were going to be difficult for somebody to use and enter, which made it even harder for somebody to opt out. Again, just making it difficult, putting up roadblocks. The other factor here was kids' data. They were basically selling and sharing minors' information without consent. The agency said, hey, you knew children were likely watching the shows based upon other factors we considered, based on how other details we know about your program. But you didn't take steps to limit that. You didn't offer kids profiles. You didn't turn off collection or sales or sharing for accounts that had parental controls on, or on stations that you knew were targeted towards minors. So again, it's another instance of a regulator focusing on opt-out issues and minors' data. I think those are continue to be themes over and over again. And the third one I might add would be privacy policy disclosures, but we're seeing these things, low hanging fruit, minors, opt outs, policies. Really focus on those when you're thinking about your compliance risks. And then when we think about what the impact was in terms of the settlement, a smaller fine than Tractor Supply, only 530,000, still no walk in the park. They needed to make an easier opt out process. They needed to test and stop using dark patterns. So, no hard to find links, no confirmation screens, and avoid confusing language. They also have to have a compliance program. They're going to be reporting to the agency for 3 years and create defaults to protect minors' data. Not major surprises here. Would be kind of what you'd expect in terms of the settlements.
Thank you, Josh. We had a few questions come in
Yeah.
regarding the opt-outs as well as automated decision-making and risk assessments. So from Audra, if companies take the position that they're not selling or sharing personal data as defined by California, would they be expected to configure their website to honor the opt-out act or opt-me out act, I think? OOPS.
So the law technically doesn't address that, but I would say that if you're not selling or sharing, it's unlikely that you'd have to honor because there's nothing you can honor. If you're not selling or sharing data, the signal has no application. But again, it's an area, it's a gray area at this point. But as a practical matter, what would honoring it do? Because you don't have any sale or sharing.
Makes sense. Uh, Going outside of California, from Jude's, many companies are receiving legal notices under state wiretap laws, California, Pennsylvania, and Florida, arguing that tools like session replay and behavioral tracking require explicit opt-in consent. In practice, should organizations treat these high-risk trackers and adopt a GDPR-style opt-in model for safety, even though federal privacy law is still opt-out based?
That just comes down to, I think, a risk benefit. I mean, I think that when you talk to your marketing and your business teams, they might be a lot more concerned about, hey, what kind of data are we going to lose, and what's the risk of the paying maybe a nuisance settlement versus the analytics and the advertising value we get from those cookies. But I have seen there has been a trend towards some going more for the opt-in approach to try to defeat those lawsuits. It has its benefits. You can reduce your risks there, but there might also be less severe approaches you can take, like some cookie banners, more of like acknowledgement banners that may not technically avoid liability under those laws, but make it less likely that you'll be targeted because you're less of low hanging fruit.
Thank you. We're getting several questions now. Okay, so if someone opts out initially from data sharing, sh should they have the opportunity sorry, so if someone opts in initially and they want to opt out later, is that something that is required to be offered as if they go back to the same website and want to opt out?
Yes. So if they're opted in, basically they're saying, I have consented, but under every state privacy law, you have that right to withdraw consent.
Okay. Uh, okay. All right. It's very difficult for marketing departments to clearly explain what is being done with analytics, cookies, etc., because they also don't always understand. Do you have any recommendations on how to ensure better information sharing about what's to be done and what's being done?
So that actually leads right into, I just wanted
There we
to
go.
egg that as my first practical tip. Um, Creating a cookie inventory, I think, is the most important thing a business can do at this point in terms of easy compliance measures. I've seen a lot of companies where they have all these cookies, all these trackers on their website, and people don't know what they did. The person who put them on there left 2 years ago, and it's hard to figure out what exactly it does. So putting in that groundwork at the beginning and maybe now reassessing, saying, hey, we didn't do this 2 years ago, but we're going to sit down, take a couple of days, work with the experts, figure out what does each of these cookies do, document it, and then as you update your website, you update your inventory. And that way you can understand both what's on your website and also properly categorize things for opt-outs. One of the major themes we've also seen is people relying on cookie management platforms to categorize cookies and say, oh, well, this cookie is an advertising cookie, this one's an analytics cookie because our cookie management platform did that. Those can be wrong a lot of the time. It does require really not just this automated approach, but really a manual review. And time consuming at the outset, yes, but worth it in the long run for ensuring compliance because we have seen regulators go after these sales and sharing. And if you are miscategorizing cookies, I think you're at a risk not only from the regulators, but also private plaintiffs. Because you say, hey, we turned off you opted out of advertising cookies, but we actually had this cookie that is an advertising cookie, but we categorized it as analytics. It's still going to be firing. You're still not compliant. So that inventory and verification is really important.
Awesome. Couple more questions we got. To what extent must covered businesses honor requests to produce correct data regardless of sharing?
So one more time.
To what extent must covered businesses honor requests to produce correct data regardless of sharing?
So if this is about an access request, the access request would be independent of your sharing. So you have your right under the CCPA to access data, correct data, delete data, and opt out. And those operate independently. So if somebody wants to access or correct their data, they have that right regardless of whether you're actually sharing that information with third parties.
Great. Couple more. Going back to automated decision making, would using that to validate the authenticity of consumer contact information be in scope for these rights?
I think it would really depend on why and how that data is being, how that process is playing out. A lot of these are going to be really case specific, but focus on the big picture of what's the ultimate decision being made. So is it in furtherance of one of these significant decisions? So again, that credit, that lending, the housing, medical, and put in that context.
Okay, we have two more. We have 2 minutes left. Revisiting risk assessments. When it comes to reassessing processing activities, what's the expectation for documenting these when/if there have not been any changes to the processing? Is the CPPA looking for documentation that confirms a review of the activity has been completed and the level of risk and mitigations remain the same?
Yeah, we don't. Again, it's a lot of unclear, lack of clarity at this point. We're going to wait for more guidance from CPPA and the California AG. But my recommendation would be document, document, document. If you say, hey, after 3 years, we still think it's the same processing, risks haven't changed, say we did this. We looked over it. It can be a short 2 paragraph, 1 paragraph, couple sentences. John and Jane looked over this, determined the same risk, same processing, no changes are needed to the risk assessment. Check.
Awesome. We have two more actually. If we've got time. Can you comment on cookie categories that must offer choice versus always active? Is this changing in the US?
So it will vary if you're looking at like private claims, so like wiretap and those can be a broader category. I think we've seen even some trying to target analytic cookies such as session replay, things along those lines. But in terms of opt out, we're looking really at your advertising cookies and cookies that might be considered a sale. So do you have a DPA in place with the recipient can be kind of a guiding light.
Okay, great. And last one, how is sharing being defined/distinguished if only used for internal purposes versus by third-party vendors? Is specific DPA's language required, and is this sufficient to cover such use?
So if you're just sharing, you're using the data internally within the same company, not going to be a sale or share. But once you start moving it to other companies, you got to be considering, okay, are we getting money or something of value for it? Or is there a DPA in place? Those kind of considerations. What is the purpose that we're sharing that data for? Are they really a third-party recipient, or are they a data processor?
Thank you, Josh. Yeah, I think that wraps up all of our questions. Thank you for all the questions, everyone. I think this has been a very informative and engaging session. Yeah, Josh did a great job covering all of the new updates. It's been a lot of updates. Um, yeah, I'll just plug our next webinar. So we have, and next week we are um, discussing with ESRB. So they are a privacy certification arm of ESRB for video games and toys. And they're going to be discussing how they use Privado AI to automate privacy audits for websites and apps to certify their member companies and what they're focusing on with all these regulatory changes. So yeah, please join next Wednesday. And also, if you want to learn more about Privado AI, you can join that webinar or go to our website, and we have several solutions to help ensure that your websites, your apps, your software, your products, your organization is not sharing data that's against the regulations we discussed today, and then including other ones such as GDPR. So, yeah, happy to discuss that more next week. And thanks again to Josh for presenting today and for everyone attending. Thanks again.
Thanks, everyone.
Bye.